Hello, everyone, and thank you for joining us here today. My name is Anna Lindgren-Tanga, and I'm a professional development lawyer with the Canadian Corporate Counsel Association. And on behalf of the CCCA, we'd like to welcome all of our attendees from across Canada. Before we begin, we'd like to quickly thank our sponsor for this program, LexisNexis. And before we hand it over to our moderator from LexisNexis, I'll just briefly cover a few housekeeping items for everyone. If you need any technical support at any time during the program, please use the chat box at the bottom of your Zoom window. And if you have any questions for our panelists, please type them in the Q&A box, and our panelists will aim to address your questions during the scheduled Q&A time slots during the presentation. This program is accredited as a professional development activity in jurisdictions across Canada. So please stay tuned for an email after the program with information about the accreditation for your jurisdiction. As well, today's program is being recorded. So again, we'll stay tuned for an email with information on how to access the archived recording, as well as the takeaway materials that have been prepared for this session. Finally, we just wanted to let you know that we have a feedback survey that we really encourage everyone to take after the program. If you can share your comments and ideas with us, that would be great, as this helps to shape our future programming. And now, without further ado, I will turn it over to our moderator for today's session, Juliana Saxberg from LexisNexis. Juliana, if you'd like to take a moment to introduce yourself and everyone.
Hi, everybody. Can you hear me? Am I still on mute? Okay, good. I'm not. Hi. I'm struggling here to try to manage all of the different tasks of the moderator. Thank you, everybody. Welcome for coming. Thank you for coming. Welcome to our session. I'm really excited for the panel that we have today. Before we get started, I did want to go ahead and share a land acknowledgement because it is a very special week here in Canada when we recognize our commitment to truth and reconciliation. I was recently looking for some guidance on how to do land acknowledgements, and I got some really awesome advice from a leader that I know online, which was don't go ahead and copy it. Try to write one yourself that captures what you really want to say and comes from your heart. And so this is my shot at that. And I will quickly read it to you and then we'll get on with the show. But in honor of the week that it is, I do want to acknowledge that the traditional territory, which I'm coming to you from right now, just outside of Ottawa, is the unceded territory of the Algonquin Anishinaabe people, and that I'm grateful to the generations of people who stewarded this land and these waters since time immemorial. And I also want to take a moment to acknowledge the harms that were caused by colonization and to affirm my commitment to truth and reconciliation in my community, in my work, and in particular, to continue working to bring justice for murdered and missing Indigenous women and girls across our country. Without further ado, I will go ahead and introduce our session and our panelists. Oh my gosh, I feel like I'm doing such a pro job of this. Here we go. Okay, well, we have such a great panel today. Our first speaker will be Fernando Garcia, the Senior Vice President at a longtime in-house counsel and a very experienced in-house counsel with Cargojet, if I can say that, Fernando. Thank you for joining us. It's a real honor to have you. Next, I have a dear friend and colleague, Amy Sandu, who is with Alstom these days and has also a very long history of working for different companies, in-house counsel, and supporting in-house counsel with coaching and training, and has been a mentor to me in the past for many things. So welcome, Amy. Thank you for coming. And finally, Anna Keller. I had the wonderful pleasure to meet Anna this summer at an event here in Ottawa. Anna's senior counsel at the Canadian Commercial Corp, which is a big crown agency that deals with a lot of complicated commercial arrangements in sensitive global industries. And so I'm super excited to have this amazing panel of heavy hitters to really dig into talking about how we communicate the value of when we've avoided a risk. Because I think, just to set the stage a tiny bit, I would say, generally speaking, I think we're all really used to measuring the worth of in-house counsel in terms of dollars spent versus dollars saved spending on external counsel. And I personally consider that a very unimaginative and limiting way to look at the value that in-house counsel brings. Because when in-house counsel is embedded within the leadership of an organization, you really have opportunities to really incorporate intelligent risk management and risk governance within your agents or within your entities. But sometimes it's hard to convince people that we need to be properly resourced, with people, with technology, with office space, with infrastructure. And so the point of this session was really to build on some of the work we did last year. I don't know if everybody on the call was with us for our budgeting webinars, but we really want to take that one step forward and really dig into how do we show the entity the value of all of the losses and all of the disasters we've prevented. So with that, I'm going to go ahead and ask Fernando to kick it off with some comments about, what is the role of in-house counsel, speaking of risk management.
Sure. Thank you very much. Good afternoon, everyone. I think the first thing we need to acknowledge is the fact that we're not always avoiding risk. I mean, avoiding risk is necessary in what we do every day, whether you're flying airplanes, driving trucks, building products. There's risk. There's risk in everything we do. There's risks in everything our client does and just within the environment that we operate in. So the key is not necessarily avoiding risk, but really to taking steps and initiatives that we can do as in-house counsel to minimize the risk, the effect that the risk would have or of the risk happening. So really the key is about strategies and steps we can do to minimize the risk. And there's also elements of sharing the risk in terms of insurance or working with partners or developing contractual obligations that shift the risk away from us and push it towards our suppliers or our customers or someone else. So really it's not necessarily just about avoiding risk, but really how to mitigate or how to manage the risk. And risk management itself is basically a set of processes by which an organization identifies risks, prioritizes them, and then develops a plan to address and to try to manage those risks. Now, I think when you look at it, especially the small in-house departments, it's very easy for us to say, well, look, I don't have a lot of resources. There's not much I can do with regard to this. But I think when we actually look at what we do on a day-to-day basis, we are doing risk management, whether we understand it as such or whether we call it something else. But really, it's in every single thing that we do every single day. So contract reviews, very, very important. Like we talked about, NDAs, using contract templates, dealing with contractual disputes. When you're doing that, you're basically shifting the risk or you're minimizing the risk. If you have a corporate secretarial role, you're working with the board to try to inform them of risks that are happening, keep them up to speed or up to date in terms of changes in the industry within which you're operating, and really working with each other to try to safeguard the needs and of the shareholders and stakeholders and other members of the team. Our day-to-day development of policies and procedures, whether HR or corporate policies and procedures, another very strong way in which we're adding value by developing the groundwork and the expectations and just really determining what happens in the event of certain risks happening. Litigation management, easy one to understand that, if you're being sued or if you're looking at suing for breach of contract or anything else, you're managing the risk and you're shifting the risk and you're trying to protect the interests of your client. HR and labor relations, obviously employment agreements, terminations, harassment investigations, developing policies and procedures for whistleblowing. Those are all key important steps in managing and dealing with the risk. IP protection, crisis management preparations. That's another way that we often add value is we hope things don't happen, but we have to be prepared that in the event that they do, what are we doing? It's very hard if a situation arises to be running around trying to make rules and follow processes on the fly. So it's important to have preparation, and preparation means, cybersecurity preparations, incident response preparations, environmental incident preparations. For example, in an airline, you would have a critical incident team where everybody knows exactly what they're doing. If something happens, there's a plan in place. We're going to meet here. Everyone's going to have access. There's a backup in case we can't find somebody. Everybody has a clear understanding of what your role is, who you're calling, when they're being called, in what order, and so that it's prepared and it is something that it almost comes naturally. And unfortunately, it's hard to say because it's something you don't want to think about, but it's good that in the event it happens, you're able to just naturally respond. It almost becomes mechanical in your response because you know what to do, what you're responsible for, who's doing what. You don't need to be coordinating with anyone else. You know that they're doing their job, you're doing yours, and you're resulting in dealing with that risk.
So
really
I really
Sorry.
Oh, sorry.
Yeah.
I didn't mean to cut you off, but I wanted to say I really appreciate the overview of, that, or the acknowledgement, I guess, that counsel has a role to play in enterprise risk management, whether that's you're advising the board, but definitely in that middle layer where we're giving design guidance, et cetera, to business units that are, they're really engaging with the risks, right? And I wonder if you could comment a bit more on, what is legal counsel's direct obligation here? Because I think in a lot of organizations, we have these beautiful hypothetical governance models, like this beautiful enterprise risk management model that's kind of, universally accepted as being great, but it really only fits for a very well established, sophisticated organization that maybe has audit and risk and compliance and legal, and maybe they have an advisory board. And so for knowing that most of our Canadian enterprises are actually, most of the employers in Canada are SMEs, right? I mean, most of the people that work in Canada are employed by organizations with less than 500 employees. I got a stat on that, which I'll put in the discussion paper that you're going to get after the webinar for anybody who's curious. So how do we apply that? What is counsel's role, and how do we get it going when you're working in a small team that maybe doesn't have those clear separations between audit, compliant, risk?
Yeah, I think it's actually even more important when you're in a smaller team. When you're in a larger team, it's almost like my incident response example, where everybody knows what they're doing. You are responsible for a particular set of expectations or duties and tasks. When you're in a smaller department, you are basically a lot of these functions, and you have to take on that leadership role. And, we often talk about in-house counsel and general counsels having a seat at the table. And that's really what it means. It means that we are now responsible for the leadership in the event of these situations. And I think in-house counsel, basically, because of our role of touching and working with all these various departments, we almost become like the hub of that tire, of the wheel, where everybody sort of comes and towards us looking for leadership and approach in that. So I almost see it the opposite way. I think the smaller you are, the more you have to take responsibility with that, whether it's formal, whether it's part of your job title or not. In the event of something happening, in the event of a risk materializing, you will be the person that everybody turns to and says, okay, now what? So whether they're formal processes and, that are vetted and spread and communicated, or they're things that you hold at the side of your desk and say, well, in the event of this is what I'm going to be doing. I think it's very, very important because, again, preparation is critical in the event when you're caught in a situation where time is urgent and the stakes are really high.
I really appreciate those answers. I've got a hand up from Anna. Amy, you were next on our list. I do want to put both of you on the hot seat. Anna, do you want to go first? And then Amy, I'll ask you to weigh in.
Yeah, I just wanted to comment on that. And this is something someone told me, a quote from someone else, but they said, as in-house counsel, we have all the responsibility and none of the power. Meaning that when there's a risk, we have all the responsibility for managing the risk, but none of the power to do anything about it. So what we really have to do as in-house counsel is we have to convince other people that there is a risk. and that they need to do something about that, meaning that the clients, the business folks, the people who are making those decisions within the business. And I'm going to speak a little bit about how we do that a bit further along in the presentation here. But I think it's a real challenge for us because we can see the risks, but we often don't have the authority within the business to make the call to actually fix it. And I think that's something we struggle with as in-house counsel. That's the reality of our job.
Mm-hmm.
Go ahead, Amy. Sorry.
While I was listening to Fernando, I was really struck by an experience that I had several years ago. And as some of you may be aware, I was a full-time ethics officer for many years. And one of the things about that experience that I had was that it took me a full 6 months at the beginning of that role to change my in-house counsel, my legal mindset. And I physically remember like my brain moving around and transforming. It's like having braces on my brain, where I went from this model of reacting and being reactive and trying to be that partner for the business team to being proactive, right? What are the things that I need to drive? What are the things that I need to push and plan and have like a 1, 6, 12-month plan to bring forward items to the management team, whatever level I was working with, and to basically explain the problem and set out all the mechanisms and all the steps and policies, whatever that would need to be implemented, explain what I would be doing as an implementer and what I was responsible for, and explaining what they would need to take ownership of, and then have the ability to track it and to drive it and to report on it. And so I found that to be a very different kind of role than when I've been in in-house roles, where so much of your role is really being responsive to the business. And so I think that if you really want to, in my view, if you want to be really successful in this, you have to be spending your time thinking about how do we prevent these things, right? How do we put ourselves in a position where we are so aware of these risks that we are actively planning how we're going to avoid these risks? Or to Fernando's earlier comment, do we understand the risks and have we put in place a mitigation plan, or are we accepting the risks? And to Anna's point, a lot of the times the decision to accept the risk comes from the business, right? They're the ones who are going to say, no, you know what, we really are not that interested at this moment in updating the mechanisms of how our software and our website design works in order to be in compliance with new privacy legislation. Thank you for telling us about this, but we're making the decision to not worry about that this quarter or this year, or whatever the other topic might be. And so I think that it's very important for in-house counsel, especially if you're used to being in a reactive mode, which that is the nature of the job a lot of the times, is how, you got to map out what it is that you want the company to achieve, and then clarify what is your role in that, and clarify what would be the role of others, and then work to get buy-in of this plan.
Right.
Because that, as Anna is saying, you're basically identifying risks, but you need other people to implement them. No one's going to implement anything unless they've bought into it, unless they feel like those targets are now somehow connected to their performance evaluations, whether it's individual or as a team, right? So that buy-in really has to happen at a very senior level and at an initial level. And I think in-house counsel needs to find a way to sort of isolate their role in it from that of others, so they're able to demonstrate, I did my role, I met my obligations in order to raise this to you, present to you with draft 1 of a plan on how we might implement this along with a timeline. And now here are my collaborators who we're waiting to receive the input from so that it can advance to the next step. I'm going into this in great detail because I remember how difficult it was to make that transition in that thinking process. And I can imagine it's even more magnified when you're on a smaller or less resourced team, where the less resourced your team is, the more you're going to be in a reactive situation.
Mm-hmm.
I want to give Fernando and Anna a chance to respond to that before we jump into like the nuts and bolts of how we can really show and demonstrate that, that's also bringing value, right? To
Right.
communicate to senior leadership that they do actually want to invest in our risk management activities. And we do actually have a legitimate role to play, which I think we've covered. And then we have a question in the Q&A. So before I turn it back to you, I just want to remind everybody, please go ahead and put your questions in the Q&A. We'd love to answer them and make this as interactive as possible. So Fernando, Anna, do you want to respond to what?
Yeah, definitely. I think culture is important as well. I think different locations, different clients have different risk tolerances. So part of it, I think, is also incumbent on you to learn what the business is very, very closely. Understand what the risk tolerance is. Gain the trust, and then once you do that, they know that you're not part of the problem, you're part of a solution. Once they know that they can come to you for issues, that you're not the department of no or where good ideas go to die. Once you get the buy-in, once you build that relationship, it makes it that much easier to say to them, listen, I understand what we need to do. I understand how we're going to get to that objective. There's a less risky way of doing it. These are things we need to be mindful of. And I think once you have that trust and you have that level of buy-in, I think it makes it that much easier. So, when we talk about it, a lot of this is cultural change. And to be able to be part of the cultural change, you have to be part of the change agent or the change leader. You have to be able to get support from the top that, these are strategies that doesn't undermine the goal of the organization, or it's actually, if anything, forwarding it by doing so with minimizing the risk. So I think that it's almost like a seed you start planting from the first day you begin to integrate yourself, to be part of, and to gain the trust and support of all of those around you. So that, the comment that was made was power. So there's formal power by title or position, but there's also the informal power. And that's the one that I think oftentimes is even more important, and the one that takes a bit more time to build. But once you build it, that's much more powerful than just the title.
Thank you. Anna?
Yeah, I'd agree. It's very cultural. And if you're new to your organization, this is something you want to take a look at. And I'll say this, I was in-house at a big law firm for, many years, where I was in private practice at a law firm for many years, where you're trying to guard against all risk, right? Like you're advising your client against all risk. That's your job. And then I went in-house at a tech company where they were willing to take huge risks. Like
right.
You couldn't say no to anything. Like their motto was literally move fast and break things. And I was running around saying, we move slower and break less. Like that was what was going on. And now I work for a federal crown corporation where there is a lot less appetite for risk. Like there is very little appetite. So understanding that culture and where you fit in, because I think to Fernando's point, you can't be the department of no. Like you can't say no all the time because you're literally then the lawyer that cries wolf, right? Like if you say no to everything, then inevitably what happens is, you'll say like there's litigation risk. Well, there's always litigation risk. So inevitably there's no litigation. And then it just looks like, well, the lawyers are just saying no because they want to say no to everything, right? Like you look in the meantime, as the lawyer, you're like, wow, we just got lucky. There was no litigation risk. But that's the challenge, right? So you've got to find that balance of like how to say no to the really important stuff, whereas letting the other stuff, sort of proceed with some risk tolerance or risk management. So that's definitely our challenge as legal counsel, but that starts with understanding the culture of your business and how you fit into that. Because if you're in tech and you say no to everything, you're not going to last very long.
And sometimes they want litigation, right? You might say litigation is not necessarily the best answer, but maybe it has another purpose. And so you have to really dig deeper into what is the intent there. And sometimes there are things where a message is trying to be sent or a new approach is trying to be developed, or they're willing to take that risk. And even if you tell them over and over again that that's not the best approach, that might be a reason for it. And so you have to really delve in there and get, I think once you have that trust with them, they're able to better understand why it is that we're doing this and maybe to look for alternatives. But maybe not. Maybe sometimes you just got to say, listen, I've advised you of the risk. You've decided to take it. Let's work with it now.
go ahead and break things. Yeah, go ahead.
Yeah.
Obviously, with our
that's
ethical obligations too, right?
Yeah.
Because we do have the element too.
It's you almost answered the first question in our Q&A, so I'm going to say the question, I'm going to ask Amy to answer it, okay, which is, how do you balance the issue of appearing too risk averse, thereby affecting your credibility, versus having to wear that lawyer hat and discuss downsides of scenarios? Any tips, Amy?
I think the key is really trying to understand what the person in front of you, like, what is their objective, right? Like, I think that's critical, whether they're a senior leader, whether they are a more up and coming leader or a new person. Why are they talking to you, right? They're talking to you because they want some kind of assistance. And sometimes what they're asking you, and I've come across this in some organizations more than in other organizations, where there might not be as clear in expressing the help that they need as in other organizations. So I think the first step is really understand what is it that they are trying to achieve, and let them understand that you understand what they are trying to achieve. Right? Like literally, like, play it back to them. Okay, I understand that, the objective of this opportunity or this bid or this project or this opportunity is to create X, Y, and Z opportunity for us, or to fix A, B, or C problem for a potential client. So
I know.
First of all, no, go ahead.
I cut you off there. I'm so sorry. I know we could talk about this topic all day, but I'm keeping an eye on the time because, of course, I've lost control of the agenda, which always happens. Amy, I want to invite you, because there's a question in the chat, I think, that sets up this question really maybe sort of well, which is, how do we get to talk about, I'll read the question because it's better than I could say it. In an environment, by the way, the question is written for Anna. In an environment where the risk appetite is very high, how do you actually prove value when you're not really limiting or stopping anything, or they're just not taking your advice? Is your value just in fixing things when they're broken? How do we approach that? I don't know if that's a good segue into your comments or not. If it isn't, feel free to answer the question you want.
Sure.
Okay.
So I think that we can't give a recipe for all scenarios, because a lot of it depends on the maturity of the organization and how they understand the role of a lawyer. Like, let's just let's just call a spade a spade. Some organizations, especially if they've never had in-house counsel before, or they've had negative experience with in-house counsel, they don't necessarily understand, right? What value you can bring, and it's a longer term relationship to explain it to them, or to show them. Let's show them. But in terms of organizations where, or parts of an organization where their risk appetite, let's say, is beyond what you think is appropriate, or like, just because they think one thing or the company's mandate is one thing doesn't mean that there's no value in bringing up different points of view. I mean, that's what diversity of thought is, right? I used to have a boss who said to me, if both of us think the same thing, one of us does not need to be here. Because then there's because in his view, there's no contribution unless we were like exchanging ideas and challenging each other, right? If we both think the same thing, what's the second person adding? And he didn't say that was me, it could have been him. So I think what I would do in a situation where there was a lot of risk that, the eager beaver business people didn't necessarily identify, or they were focusing on, they had like more of a positive bias, right? A positive outcome bias, is I would look to similar companies, either in the same industry or the similar trajectory, and point out, let's say, very well-known examples of situations where that company had a huge problem. Because in my experience, people really can see the value if you give an example or if you have a story to tell. So they're not that interested always in this is theoretically what could happen, but it's more compelling if you say, let's make sure we understand what happened to our competitor when they fell off this cliff, so that we make sure we stay away from the cliff, or let's make sure we understand what happened to a supplier that failed or someone in a similar industry of a similar age. And there's so many examples. It's not difficult to find an example. So that's how I would approach it. And if I had more information, I might say that, the lessons learned from that example point to a gap in this element of the risk analysis. Have we satisfied ourselves that we have done a risk analysis that factored in X or Y? And sometimes they will say, oh, we haven't done that yet. Thanks for the input. Or they will say, you know what, we did do that, and we are comfortable with accepting this risk, in which case you should document that. And then, support them along the way because they have made that decision now. But sometimes also what I have found is that, and this goes to the soft power element, is has the approval come from the right level within the organization, right? Are there other people within the organization who might be more experienced or more senior where they would not approve something like that? And so sometimes you need to engage with them to see if that business team has received the input from all areas where they should either receive input from, or sometimes you can flag to them. And I remember this in one organization where there was this really gung-ho team wanting to do X and Y. And I was able to say, I was supporting a similar team that was doing something similar. And I know that 3 steps down the road, it has to go to approval at this level of management. That level of management said no to the opportunity, which looks very similar to yours. I would hate for you to waste your time. Would it be valuable for you to flag it to that person now rather than doing all of this work and getting no in 3 months' time? Sure enough, they took the advice, they went to talk to the person said no, and they saved themselves months of work before getting to that no at the next level.
Brilliant. Thank you so much for sharing that anecdote. Listen, I want to just do a couple of points for wayfinding. Number one, I think we have to step away from the agenda that we prepared because we're getting so many great questions, and I want to keep this back and forth going, this repartee. And number two, I just want to let everybody know on the call that if we don't get to a topic that you wanted to see discussed today, I have prepared a very extensive practice note that goes through all the concepts that we're talking about today that you'll get with the follow-up materials. And you can review that, and then you'll also be able to rewatch the session if you want to. And so with that, I'm just going to say, go ahead, get into the question and answer. I'm going to turn it over to Anna, and I'm going to take a step back and try to just let you guys get out what you need to say.
Yeah, so I think going back to sort of the title of this presentation, how do we capture the value of risk management? So capturing, I think we've established that what we're doing is providing a lot of value. We provide, risk management is a big part of what In-house Counsel does. That's great. We got to capture that and, portray it to other people and be like, hey, we're doing a really good thing here, right? That's what we're trying to capture that value. So how do we do that? And the tricky part for lawyers, I think, is that if we do our job really, really well, no one notices. Right? Because our goal is that the business carries on status quo. So if we de-risk a situation, whether it's putting great clauses in a contract, we do a great negotiation, we find a solution to a problem, the answer is the best case scenario is that business carries on as normal. Right. So now there's no parade when we do our job really well. It goes back to that quote, if you wanted applause, join the circus. You're not going to get any as in-house counsel. You're not gonna,
yeah.
So how do we capture the value if it's not, if fireworks don't go off when we negotiate the best contract ever or whatever the case might be? And I think it goes to the fact that risk falls into 2 categories. So you've got risks that save money, which to me are sort of obvious risks that businesses really like you to talk about because it's going to save them money immediately. So tax risk going around warranties if you have a product that you're selling, accounts receivable risk, regulatory fines, that's the stuff that saves the money. They can see that and see the tangible value in what you're bringing because it equals a dollar sign. The stuff that's harder for us to be to sort of quantify is risks that cost money. So the risks that cost money are the stuff that keep us all up at night. So litigation risk, reputational risk, supply chain, cybersecurity, ESG reporting, privacy issues. Like, this is stuff that's intangible in the sense that if a bad thing happens, we don't necessarily know the dollar sign that's going to be attached to it. We just know it's going to be really bad. Right. And we often talk about these intangible risks that cost money, but it's difficult for us to portray that risk to the client necessarily because we don't have an immediate dollar figure, or we're not exactly sure how bad it's going to be. So I think our challenge is we have to capture that and portray to our client, hey, we're warding off against a lot of these risks. Look at the value we're bringing. Like, how do we capture the value of risk management? And I think it goes back to that idea of you can't measure what you don't track. So as lawyers, and we're not great at this because we're often putting out fires so fast, you have to start tracking your risk management. And for me, one of those ideas is, and this is something I've done in the past, is as simple as a spreadsheet or however it makes sense for you to report risk. But literally, start listing your risks on the spreadsheet of the stuff you're doing. So like contractual risk around audit clause, regulatory risk around fines, litigation risk around whatever, list it on your spreadsheet and categorize that by color. So red, yellow, and green. Green is an acceptable risk. That's an ongoing cost of doing business risk. We're okay with that. A yellow risk is problematic, right? It's going to be costly. It's going to be uncomfortable, but the business survives. Red risks are the stuff we're really trying to avoid. That's the catastrophic business risks. That's the reputational damage risks, the loss of license, the financial ruin in litigation, the stuff that, like, as lawyers, that's catastrophic. And for your clients, I think it's helpful to even show them your spreadsheet. Be like, hey, okay, if you meet with your client, whether it be if you're a junior lawyer and you're meeting with a senior lawyer, or you're a senior or general counsel and you're meeting with the C-suite, categorize your risks, show them the spreadsheet and say, okay, for this project, this week, this month, these are the risks I've identified. Here's my red, yellow, green synopsis. We really need to focus on these red ones. Here's the yellow, here's the green. And ask for the buy-in. Like, do you see, have I color coded this wrong? Do you see this differently than I do from a business perspective? And the value in doing this is you get your buy-in in the risks. You provided them with a scenario they understand, right? Color coding is easy for everybody. And where it shows value for us, like how we capture the value for the legal department, is the next time you report back to them, you change your color coding. So your red risk just became yellow. And you can say, hey, this was a red risk, last month, last week. I have done X, Y, and Z, and now it's a yellow risk. Like, now I think we can manage it. Or I brought it from yellow to green because I've done this. And now you found a way to tangibly show what you're doing. It's also great from a tracking perspective because at the end of the year, when they said, what value does legal bring and why do you want to increase your budget? You can say, hey, I took 25 red risks and turned them into yellow, or I took so many yellow risks and turned them into green, right? You can show what you've done. Whereas, often at the end of the year where they're like, what did legal do? And you're like, oh my gosh, what didn't I do? But how do I show it? How do I capture what I've just done in the last year or what's happening? So I think it's a way to capture risk management and show your internal clients that you're doing something and also get them to buy into the risks that you're doing.
Awesome. So just to sum up again, Amy said, find some really great examples out there of compliance or risk failures and describe them, make a narrative and present that to your internal client as an example of the type of thing that you're avoiding with your proactive approach. Anna said, make sure that we are always documenting and presenting and reporting, even though we'll say we didn't go in-house to fill out a docket. Unfortunately, we can't get away from that. Fernando.
One thing, sorry, I had to step off for a second to deal with an issue.
That's okay. Oh my gosh, I was wondering.
Yeah, indeed. One thing I do want to caution though, be careful with the privilege element as well. Because if you're identifying something as red flagged and it sits there unchanged for a year, and then something happens with that red flag, you want to make sure that the documentation is also privileged with regard to your communications. Otherwise, you're basically admitting that you've had this red flag issue that nobody really cared to deal with. And you're basically admitting liability to some extent or creating a potential liability in that sense. So you got to make sure that one of the advantages that in-house counsel have is that we do have the right to privilege and over some of the documentation. And that's definitely one where you have to make sure your legal advice you're using as legal advice and not necessarily just as a compliance person.
Yeah, important point is to make sure that when we're communicating about risk, that we do it in a way that makes it clear that that the communication is legal advice and it's privileged. And that, I guess, is an element of legal risk that we're also managing. This is getting very meta. What do you want to do next? You want to go to the question and answer, or do you want to talk about more methods of showing that we've returned value by avoiding disasters?
I'd like to stick on that topic, just because I think that this might be helpful to individuals who are facing some of these issues for the first time, or if they're looking for some sort of like template in terms of how to talk about value of problems that they are avoiding. So let's say if we were to talk about corruption risk, okay? Mm-hmm. One of the things that a lot of people don't understand is all of the knock-on effects that some kind of a scandal could have. So on the one hand, you could explain to your colleagues, and you could have a template that's ready that you could then help them to organize their thinking for many risks. Is you could talk about what the legal penalties can be. So whether it's jail time, fines, whether it's legal costs for lawyers, whether it's investigation costs, you can kind of identify for people, here's one bucket of consequences, right? Secondly, and what a lot of people don't realize is that there are a lot of other consequences. For example, there could be a drop in share price. There could be class actions brought by shareholder communities, right? There could be the investigation into you, or allegations brought against you, might be enough for your contracts that are currently in existence to be terminated, or at a minimum to kind of be called to the carpet by the client to explain. Or you might have obligations under all your other contracts to disclose what is happening. You could have consequences in terms of bank loans, interest rates on bank loans, whether you can get new bank loans. Rating agencies might have something to say. You could also have implications on your ability to get new business. So for now, if you have a government client, if you're bidding on government tenders, being involved in an investigation might be enough to disqualify you. That is one scenario. Another scenario is if you have gone through some kind of criminal sanctions or regulatory sanctions, you might be disbarred or debarred, pardon me. Disbarred, that's another topic, but you might be debarred in certain jurisdictions for certain periods of time. So a lot of the times the business community might have a sense of one of those categories. They might not have a sense that all of these things could happen to them. You know, you could have clients who won't do business with you. I've seen scenarios where suppliers will call and say, we're not sure if we want to continue working with you. You might have issues with employee retention or recruitment, on and on. So I think one thing that could be helpful if you're looking to create some kind of a tool is to almost have like 2 or 3 PowerPoints that kind of list these categories. And then separately, you could have, as I said earlier, an example of where this happened to another company. Or you could even just have like a table that says, you know, here are the top recent 10 privacy, I'll use privacy as an example, breaches and what it cost the companies, or top recent competition law breaches. Whatever, I'm just imagining that you can customize a template for yourself, where then it's easy to communicate to your business teams, here are the potential risks by category. And then here are some examples of what some of these penalties were or costs were to other companies, and either flag it by category, like I said, privacy or competition, or categorize it by these are issues that have happened in our industry. So I'm just, from a point of view of, as Anna has said, you can't really quantify what you've prevented from happening, but you can look at other companies where these things did happen and see what it costs them. Not the same thing, but it could be a helpful tool to have in your arsenal or in your toolkit.
I want to weigh in here really quickly because there's a couple of questions I think in the chat that we can sort of unite under one theme. One of them is risk mitigation needs to be owned and done by others in the organization. Like I think the traditional approach is that the business units are supposed to own their risks. They're supposed to implement the controls and they're supposed to track and assess them. So what do you do if you don't have control to make sure that risk mitigation is implemented? And then another question, which I think is really good, was I'm a junior in-house counsel and I have 3 people that's senior to me, and I'm often shut out of the meetings. I only hear about the issues when it trickles downstream. And how do we get more involved in terms of having line of sight to issues? I want to offer just an insight from our planning call, which was we had a discussion on Monday about how we were going to approach this. And Amy brought up the point, which is very well received, that in-house counsel already have way too much on our plate and you're way too thinly resourced to take too much on. And I really, really took that to heart and thought that it really isn't our job to get in there and start making, spreadsheets and doing, calculations and stuff, although we can. I think that it's also super important to clarify the role of legal in wherever you're located in enterprise risk management or enterprise risk governance, right? So if you're with a business unit, then you're supposed to be monitoring and assessing those risks and implementing controls. Lawyers are generally in the middle, sort of like the advisory professional, executive management. So we're supposed to be designing the tools and then pushing them down and then reporting up to the board. But then we also have people that are GCs that are advising the board directly, right? So I guess I'm trying to say is we all have a role to play no matter where we are in enterprise risk management, and you don't have to do it all. I mean, for most in-house counsel, all you have to do is you don't have to be a professional risk management pro that can do a big actuarial spreadsheet, but we have to capture the imagination, I guess, and make sure that we put it on the radar of those above and below. Comments? What do you think? Did I capture your concern, Amy, that you had raised with me?
Definitely, and I know that Fernando might have a different point of view, which is great because that's why we're here. We have different different value to add. I think that part of the issue is I think that all that information impacts the work that we actually do. So sometimes you want that information, to go back to the junior lawyer, because the absence of that information just makes your job harder. And if you get that information at an earlier time, you can do your job better. You're not redoing your work, and you have a better chance of impressing your coworkers, right? If you're always behind, in 10 steps behind, because you've been shut out of meetings or because the information was imagined it would get to you faster than it does, there is a risk that you don't look fully prepared to your colleagues. But I think you have to find a way of saying, based on the information that I have, this is what I've prepared. If you have more updates, we can adapt this document, right? Like kind of own the situation. Secondly, and speaking for myself, and I'm sure speaking for some of our population, I think as lawyers, some of us are control freaks. And I know, at least in my case, over my career, sometimes I want to know because I feel like I need to know at that moment. But sometimes it's okay to wait to get the information. And I think it takes, at least in my case, it took some discipline to be okay with waiting until it did come to me. But as a strategy for that individual, I would propose that they set up or have some sort of a weekly touch point with one or all of their senior legal colleagues in order to get the benefit of their experience and knowledge, and ask them, anything going on that can help me do a better job for the organization. And I'm sure that they would be happy to share to reduce the workload if you come at it from that point of view.
Reflecting on the question too, I want to say right away, that's bad client behavior. Okay. If clients are not sharing risk information with you, there's a problem in the relationship. And so what Amy said, going to your senior and saying, how can I fix this, is one thing. I want to say maybe even consider go to the business unit and say, how do I fix this? This isn't working. Anna, I want to ask, what do you think though? Because I saw your hand up.
Oh, I am. Yeah, I mean, more like practical strategies. If you're the junior lawyer, often I know as senior counsel, you just never think, especially in a virtual environment. Whereas, like, if we were in the office, I'd grab a junior lawyer and drag them with me to a meeting. Virtually, you don't think to do that necessarily. So just proactively, obviously, saying you're interested in going, offer to take notes. Everyone loves someone else taking notes. So that's a value add to your meeting. But yeah, obviously some meetings as a junior lawyer, you're not going to get invited to, and you may not be appropriate that you're there if the senior counsel is meeting with the board or the GC is meeting with the CEO. So then it's just following up afterwards and saying after the meeting or when you get your instructions via email or how it is, and being like, can I take 5 minutes to ask you some questions about that? Because as a junior in-house lawyer, sometimes your client relationship, in a bit odd ways with your senior counsel, like you're providing the work to them and they're providing it to the business. So like you have to frame it and look at it a bit differently. Like, how can I help senior counsel do this? And they're funneling it back to the business.
I think the other piece as well is, as was mentioned by Amy, people are busy. And so sometimes if they don't know you have an expressed interest in something or that something is an issue, they're probably avoiding dumping that on you to actually prevent you from having more work to do. So sometimes if you express an interest, they say, look, I'm really interested in this area. Can I get more involved? Then oftentimes it's oh, okay, I didn't even think about the fact that you might want to be involved in this. So if you don't ask, you don't get. So you have to be open in your communication as part of your training, as part of your development, to say, look, these are certain areas that I might want to develop more skill sets in, want to get more involved in. I think it's maybe jeopardizing other elements of the work that I'm doing. So can I get involved? And it's hard. I mean, I can't think of many instances in my career where a junior asks for something and says, I want to do more work. And somebody says, well, no, I don't want you involved at all. Unless there's obviously sensitivity issues for other reasons. But for the most part, I think if you ask, you're going to get it. It's a question of how do you ask and how you bring it up.
Well, we've got 5 minutes left. We've got one last question. What I propose we do is this. I want to give each one of you just a minute to, give a quick wrap up. If you have something that you really feel like is the most important takeaway for people to know from our session, and then we'll jump into that last question. And again, just for the viewers, if you have to jump off, that's fine. Do make sure, though, that we have your consent to contact you, because we're going to send you the replay and the materials. And there's a couple of great tools in there to do, the risk analysis that Anna was talking about. So I'm going to turn it over. Who wants to go first with your round robin?
I can go first, just because I had my thought. I think with my levels of years of experience now, I think what I would do differently now than I did when I was younger is I think I would clarify who is the risk owner. And sometimes the answer is, we never thought about this risk. We have no idea who the owner is. And then you follow up and you press on it. Because I think that there's a tendency to either, some people by personality or workload might push things away. Others might sort of want to bring things in. And that can't be how a decision is made about where the risk sits. Because if we look at commercial contracts, we always say that the risk should sit with the party that can control it and do something about it. So we should take that same principle internally when we think about, well, which position or which department should own the risk. We really need to think about, well, who has the ability to do something about it? So I think that's my parting idea is really seek clarity in who owns that risk or who should own that risk. And obviously it can change, right? The organization might try it and 6 months later decide, okay, well, that it didn't work out well for that organization to be leading privacy, to stick with my example, because we learned more and now we recognize that they own 30% of the risk, but someone else more appropriately owns 70% of the risk. So we'll shift it. So no harm in changing it later, but that would be my takeaway, is really identify who is the risk owner.
On my end, I guess the one key is, build a relationship, understand what the objectives are, understand what the appetite for risk is, and then work within those parameters. Again, I think it's critical in everything we do that we're seen as helping and not hindering. And so I think that's part of the solution, that we need to understand why certain things are being done, how things could be done maybe a little bit different while still achieving the goals. And I think that's how at the end of the day we can turn around and say, look, we've added value.
Yeah, not to repeat these great comments. So I'd say my last one would be, is there are two different kinds of legal departments. There are legal departments that your business clients are scared to come to because you're going to say no to everything. And there are legal departments where they want to come to you because they want your help. And you want to be the good legal department where they want your help.
Absolutely.
So your goal should be to de-risk the situation so they can do the business thing they want to do, not to say no to the business thing that they're going to have to fight you on. You don't want to be that person they have to fight. So, your goal should be to be like, they want to come to you. You want them to say, let's go ask Anna. Like, that's your goal as the lawyer. So I think it's hard to get there sometimes because we want to say no to everything, but it takes some to be the people who are like, yes, I can help you. Like, that should be your goal.
I really, really appreciated those thoughts and comments. If anyone wants to stay on, we can work through the Q&A. We've just got 2 questions, but I know a lot of people have to jump because it's your lunch hour. And so thank you for joining us. Thank you for showing up today. Thank you, panelists, for being generous with your thoughts and with your wisdom, and for working with us and for showing up like this for, our community. Really appreciate it.
Thank you. Thank you for the invitation.
Thank you very much.
Thank you.
My honor, yeah. All right. So I don't know if we're still recording, but we can jump. If anyone has to jump off, go ahead. Otherwise, I'm going to just run through this Q&A real quick. A balance-related question. How do you balance the conversation where legal identifies the matter of compliance and corporate authority, we can't do this, versus the internal decision-making view that it's a question of risk? Like, we think we can do this, and the risk of being challenged is low, but like compliance is like saying no. So how do we approach that conversation?
Well, why are they saying no? I mean, they should be able to explain why they are saying no. And if they're saying we cannot do that, it should be straightforward enough for them to explain or demonstrate where that hard no is coming from. But if it's a preference or based on experience, then they would need to again say, okay, technically we can do it, but here are the risks that I see with us doing it that way. And then once again, then you identify, well, who owns that risk? Who is the authority who can say, I'm prepared to accept that risk, whether it's technology risk or something else.
So it's a question of needing to facilitate communication and to really, Fernando had to jump. Okay, thanks. I like that. So you're just really trying to find where the difference of opinion is and really try to facilitate understanding between the two people. How about you, Anna? What do you think?
Yeah, I think it comes back to understanding the risk itself. And like I said, I always try to take like the red risk to a yellow. Like, how do I make this less risky? Because I know the business is going to do it anyway. So how do we make it a little bit better? So if you know that, saying no is going to, there isn't a business case for what you're saying. Like, the business case is to go ahead, but the risk case is to say no. Like, how do you meet somewhere in the middle? And I think if you approach it that way and tell them that's what you're trying to do, like, I'm trying to help you get to where we can keep doing this, then you're seen as a collaborative partner instead of like a roadblock to what they're trying to do.
Brilliant. All right. And then the last question is, how do we determine the appropriate size and scope of an in-house legal department? Because we're always spread thin, and how do we differentiate between being spread thin and not being sufficiently resourced? I want to say that's a really good question. It's kind of a bigger question we can answer right now, but the people that can help you answer that are literally on this call. They're the CCCA. So I know the CCCA has put together a ton of resources to help in-house counsel with wayfinding, with navigating difficult dispute or difficult situations, finding a mentor, and doing, designing and providing the appropriate support for your legal department. And we've contributed some materials to that over time. So I want to say it's a big question. It's an ongoing question. Don't be afraid to ask for help. When I had my first in-house counsel job, I had zero idea what I was doing. So the CCCA was my savior, and I reached out and I joined, and I flew out to the convention in Toronto, and I even got a mentor, which really, really helped me to even just being able to get together and talk shop about these things that you just can't talk about with your external, right? Is going to move your thinking forward. Amy, Anna, do you want to weigh in on resourcing and size?
I think it's a big question and worthy of its own session.
Yeah, let's do it again.
We'll do it again. I think that my quick answer is that it's hard to measure what you can't count. So like start keeping some sort of metric or data or whatever makes sense for your organization that you can prove you need another headcount, or you need more people, or you need that type of resource. So whether that's questions that go unanswered, tracking a spreadsheet about what you can cover and what you can't, what you would have liked to do but you couldn't do because you didn't have the resource. So just saying we're really busy, we need more headcount, that's a tough ask. But if you can go with some hard facts as to why you're looking for more headcount or what you'd like to do with it, that's an easier conversation. And easier for your C-suite to justify to whether it's the CFO or your board or whatever the case might be, that it has to get that head count. So think about what you can measure.
The other thing I would add to that is what's your turnover rate, right? Like, are people coming to your department and staying, or are they leaving because it's too thinly staffed? So that's another metric that you can factor into what Anna was saying.
Oh yeah, good idea. Well, thank you both for sticking around. Thanks to Fernando, who had to jump. I feel so honored, and you've been so generous with your time, not just for me, but for everybody who attended the call. Thank you so much. It's been I learned so many things today from this call that I'll be thinking about for a long time.
Great. Thanks, everybody.
Thank you. Thank you.